Two major Supreme Court cases today, one involving a Muslim woman in Abercrombie and Fitch. The second involves threats made on social media.
Barry Bagnado of CBS News Radio joins us via the telephone. Barry, thanks for being with us. Let's talk first about the Facebook threats. What did the judges decide?
Well, this wasn't the broad First Amendment free speech on social media ruling that a lot of people had hoped for, Vlad, but the court did clarify when someone can be charged with making threats online. In this particular case, Anthony Douglas Alanis responded to a restraining order that his wife obtained by going on Facebook and posting things like, "Is it thick enough to stop a bullet?" And after a visit from the FBI, he posted, "The next time you knock, I will touch the detonator in my pocket and we're all going to go boom." He was charged with making threats. He claimed this was all tongue-in-cheek, that he really didn't mean anything by it. And basically the Supreme Court said today that it's not enough for the government simply to show negligence. It must also show a particular mental state, and it says that requirement can be met if the government proves that the defendant knowingly sent a threat or had the knowledge that that threat or that communication would be viewed as a threat. So there's some free speech protections here, but only so much. If someone knows it's a threat or presumes that other people might think it would be that, then they can be charged.
So, Barry, does this open the door to other threats being allowed then?
That has to be clarified by lower courts, Meg, and the Supreme Court left a lot open here. But under the standard that it's set today, it's possible that Anthony Alanis could eventually be convicted. His convictions have been thrown out with this ruling. But under the standard, if the government can prove that he should have known that these postings would be viewed as a threat, then he could potentially be convicted.
Barry, I'm really curious. You've been covering SCOTUS for many, many years now, and I'm just wondering what you think or what has changed, if anything, in the way that they're looking at social media vis-a-vis the First Amendment and vis-a-vis the Bill of Rights. In other words, these things, social media is expanding. I remember rap songs, for example, Eminem's song Stan, where he basically talks about murdering his wife, you know, and now you have social media and these guys are saying this was just tongue-in-cheek. How are they looking at the technology revolution vis-a-vis the Bill of Rights?
That's a very interesting question, Vlad, and I think that issue comes up every few months here at the Supreme Court. And today, they purposefully stayed away from any broad First Amendment issues. They just focused on the statute that was involved here, so they sort of dodged the broader ruling that many had hoped to see. People are looking for clarification as to what they can post and what they can't post. This provides some guidance, but not that broader ruling that a lot of people wanted.
All right, really intriguing for First Amendment advocates. Barry Bagnado, thank you so much.